So next we come to discharge of parties from liabilities. When we say that a party of the negotiable instrument is discharged from the liability. So it has two connotations. One is the discharge of the instrument. Second is the discharge of the parties. So the discharge of the instrument is discharge of one of more parties liable to the instrument. When an instrument is discharged, it ceases to be negotiable. But when the discharge of one or more parties to an instrument does not discharge the instrument, that means if an instrument is being discharged, it is the process is over, it ceases to total negotiability. But when there is a discharge of one or more parties to an instrument, it does not mean that the instrument has been discharged. So let's discuss them one by one. The first one is the discharge of instrument. How the instrument is discharged? One, by payment in due course. It is a very usual mode. Means once the payment is being made, that means the instrument is being discharged, and the payment of amount due on the instrument to the holder would result in discharge of the parties. That means the person who was liable to pay for that instrument, that if once he has made the payment, that means he with the discharge of instrument there is a discharge of parties as well. If the instrument is lost and cannot be produced, the person making the payment is entitled to be indemnified. Means if someone has made the payment on behalf of other, so the person who has made the payment in case of loss of the instrument, so the person who has made the payable must be indemnified for that payment. Next is payment is to be made by the maker or acceptor or the drawee. Next, debtor as holder. If a bill of exchange which has been negotiated is at or after maturity held by the acceptor in his own right, so all rights of action their own are extinguished. Next is by express waiver. When the holder of an instrument expressly announces his rights against all the parties to the instrument is discharged. In other words, we can say when the holder of an instrument at or after the maturity of that negotiable instrument absolutely or unconditionally re-announces his rights, in that case the negotiable instrument is discharged. Next is by cancellation. If any negotiable instrument is cancelled, and this cancellation is to be done by the holder, and the intention to cancel the instrument was to release the party from the liability, so this is being called as the discharge of the instrument. Next, we will discuss about the discharge of a party or the parties. So first is discharge by cancellation. If the holder of the instrument deliberately cancels the document because only to release the parties from their liability, so in that case this cancellation would discharge the party or parties of a negotiable instrument. So here the intention was to discharge him from the liability, and it would be inoperative if done without authority or under a mistake. Means when the intention of the holder was not to release the parties from their liability, discharge the parties from their liability, so it would not lead to discharge of parties from their liability. The intention is the main important point while deciding about the discharge of party or parties from their liability. Next is discharge by release. If the holder releases any party to instrument by any method other than the cancellation, means if the holder willingly discharge any party, willingly accept the cancellation, so this would be covered under this point. But it is important here to note that the release of one of the joint parties will not release all the parties. Means if there are two or more parties into a negotiable instrument, then if the holder of the instrument release the one party out of two, so it doesn't mean that all the parties are being released. Only the party to whom this right is being given would be released. Next is discharge by payment. So payment to the person in possession of the instrument discharges the party. It is a very usual way. Once the payment is being made, the party would automatically get discharged. So the payment must be to the holder or his agent, and payment must be of the whole amount. If some part of the amount is being paid or some performance is left, so it is not called as discharge by payment, because a few part of the performance is still left. Next is discharge by allowing drawee more than 48 hours. Let's suppose that if holder allows the drawee more than 48 hours exclusive of public holidays to consider, he will accept the bill or he will not accept the bill, and if the 48 hours has gone without any notice of acceptance, so the liability of the other person has got discharged. So all, not only the not only the only that party, but all the parties prior to that would be discharged from their liability to the holder. Next, discharge by delay in presentation of the check. If the check is not presented for payment in the reasonable time. Normally, according to present rules, the check is to be presented in the time period of 3 months. So, if the check is not presented in that specified time period, and due to that the drawer suffers actual damage, maybe or in goodwill or maybe financial losses, so in that case he is discharged to extent of such damage. Next is check payable to order. A banker who pays in due course a check drawn upon him is discharged from the liability, and where the drawer issues are the bearer checks, or the dry bank is discharged if he makes the payment to the bearer. Draft drawn by one branch or another. If the demand draft is drawn by one office of the bank upon another office of the same bank for a specified sum of money, the bank is discharged from the liability. Next is discharge by taking qualified acceptance. If the holder of the bill has assented for the qualified acceptance, so there is no condition that he should accept it. But if he do this, so this is being done at his own risk. So this will discharge all the prior parties, all the parties prior to himself from their liability. Next, discharge by operation of law. In case of death, in case of insolvency, or in case of lapse of time, or in case of merger, the parties will get discharged. Discharge by payment of altered instrument. If there is some material alteration which is being done in the negotiable instrument, it would discharge the parties from their performance. But sometimes it doesn't appear that to have been so altered. Means sometimes it is not being the materially altered, so this case would this will be a different case. But in case of material alteration, and it would discharge the parties from their liability. So payment on such an instrument discharges the party liable, provided he makes the payment according to the apparent tenor of the instrument. Next is discharge by material alteration, already being discussed. That means if instrument is materially altered without the consent of all the parties get discharged from their liability. To clear this point more, let's take an example. If the instrument was due with rupees 5,000, but one of the party without the consent of all make it rupees 4,000, so this is a material alteration, so this would discharge other parties from their liability. So when we talk about the material alteration, what it means: alteration of date, alteration of name of the parties involved, alteration of time, means when to give it, alteration of place of payment, alteration of amount, alteration of rate of interest mentioned in the instrument, alteration by the addition of new party, some new parties being added without the consent of all, and tearing of an instrument in a material part, means amount part is being left, or some date part is being torn. So that means if the any kind of alteration is being done without the consent of all these things, that means alteration of date, name, time, place, amount, rate of interest, or from tearing of an instrument in a material part, would lead to discharge of the parties from their liability.